In the previous lesson, what we did was explore the concept of causation when it came to the establishment of an actus reus for criminal law. This lesson, we're going to continue talking about this by examining the concept of causation in law, exploring the ways in which new intervening causes can contribute to the lessening of criminal sentence in some potential examples of case law. So like I've said, we introduced and examined a number of interesting factors which contributes to the issue of causation within the criminal law. Again, we are talking specifically about the actus reus of an offence, the act itself, the guilty act. This lesson is going to talk about some of these issues as well, continue to talk about it, focusing on this idea of new intervening causes and some basic principles which pertain to the causation of harm. And the idea is to essentially sum up some of the final issues that relate to causation within criminal law before we move on to looking at the mens rea of an offence, which is obviously the other side of the equation, the other element that is required for most offences in criminal law. So when we talk about causation, you will be met with, whether this is talking about causation within the context of the law of tort or within the context of the criminal law or even any other examples, but mainly those two are the main examples, you will be faced with this particular Latin phrase, this idea of novus actus interveniens. What does this essentially mean? Well, the concept and the principle of novus actus interveniens recognizes that in factual circumstances in day-to-day life, when it comes to the various different legal matters that exist, whether it be tort or whether it be criminal law, there are a multitude of different complexities that pertain to these factual matters. There are multiple different causes which may contribute to the resulting harm. And so what we talk about there is this idea of new intervening causes, novus actus interveniens. Now, the general rule for whether or not the defendant's liability is a new cause or contributes to the components of compounding damage is that the defendant will be responsible for all of the natural and possible consequences of his or her act. So given that there are a number of different consequences that could arise, which may be natural or possible, then these are what the defendant may be responsible for. It might be easier to just highlight this in a number of different case examples. So from 1983, we have the case of Crown and Paget. In this case, it was a case which essentially examined whether certain acts can be considered to be novus actus interveniens, and the result of which absolved the defendant from liability. Specifically, this was a case of murder. The defendant had kidnapped his girlfriend and in a shootout with police officers had used her as a human shield. Now, the explanation of how this takes place is a very, very long explanation. The police officers had very poor visibility, for example, and a shootout would ensue, which ultimately leads to the girlfriend being shot by the police officers when they fired upon this defendant, believing it was the defendant and not just the defendant with a human shield. The Court of Appeal held that the shot of the officer did not constitute the novus actus interveniens, and therefore the defendant ought to be convicted. So it was not a new intervening cause, the shot from the police officer. And Lord Justice Goff stated that there can, we consider, be no doubt that a reasonable act performed for the purpose of self-preservation, benign of course in itself, an act caused by the accused's own act, does not operate as a novus actus interveniens. So what we see here is an example of a police officer being accused, or at least the defendant was accused of murder, but the police officer was accused of being this new intervening cause, the shot from the police officer. But it was dismissed on the basis that this could not constitute a new intervening cause, and therefore it could not absolve the defendant of liability in this case. In 2007, we see a similar case of Crown versus Kennedy. This case examined the nature of a victim's act and whether or not the victim's act can contribute to the cause of the result and therefore possibly absolve the liability from the defendant. Ultimately, what happens in this case is the defendant will supply the victim with some Class A drugs. This was done at the request of the victim, as it normally is. You don't often have drug dealers just giving victims drugs. The victim asked for some drugs. The defendant, being a drug dealer or being a supplier, had supplied the victim with some Class A drugs. The victim then self-injected, self-administered the drug themselves, and would subsequently die as a result of this self-administration. The defendant was convicted of manslaughter, and on appeal it was held that the conviction may be overturned, owing to the fact that the victim had made their own voluntary and informed decision, and it was this voluntary and informed decision which represented a new intervening cause. Because if you think about it, the defendant can supply the victim with some Class A drugs, and the victim may decide not to inject them or self-inject them, or may inject a lesser amount such that that would lead them to not die as a result. So it doesn't necessarily make sense to suggest that the defendant's supplying of the Class A drugs was the cause of the death of the particular victim, because but for that case, you could apply the but-for test, but you could also make the case that the victim's drugs, self-administration of the drugs, represented a new intervening cause. Okay. Lord Bingham stated that the criminal law generally assumes the existence of free will. The law recognizes certain exceptions, but generally speaking, informed adults of sound mind are treated as autonomous beings, able to make their own decisions how they will act, and none of the exceptions is relied on as possibly applicable in this case. Ultimately, they made the argument that the victim's actions represented their own free will, their own autonomous decision to self-administer the drug, to self-administer the dosage of the drug that they did, and subsequently die as a result of which. And all of this contributes to the idea that they are new intervening causes. Let's contrast this case then with the case that we looked at in the previous example, the case of Wallace from 2018, because you might think that there might be some similarities, even if they resulted in two different convictions. One was acquitted and one was convicted. So how do we reconcile these two things? Because ultimately, in the case of Kennedy, the victim made the decision to administer the drugs and therefore die, and the result of which was that this represented a new intervening cause. In the case of Wallace, the victim made the decision to go to Belgium to take their own life through euthanasia, but that did not represent a new intervening cause. It was not representative of that. Well, the decision to end the victim's own life in the case of Kennedy was a voluntary decision that had no influence by the defendant. However, in the case of Wallace, this decision to end the life of the victim, this self-confessed decision, was not seen as a voluntary decision, because it was a decision that was only brought to the fray. It was only made on the basis of the attack that the defendant had incurred onto the victim, the acid attack, which resulted in his decision to go and euthanize himself. And so as a result of which, this kind of free will, autonomous, voluntary decision element is what delineates the case of Kennedy and the case of Wallace. Let's just think about some of the other issues that relate to causation in a tiny bit more detail. One of these things is known as the thin skull rule. Generally, this is the rule that states that you have to take the victim as you find them. What this essentially suggests is that if the victim of an offence has some unusual condition, which may lead to them suffering a significant more harm as a result of the actions of the defendant cannot just avoid liability on the basis of that particular characteristic. So, for example, if there's an example that we see here from Herring, which is the idea of a defendant stabbing an individual who is a haemophiliac. Maybe it was the case that the stabbing of the individual, of the victim, would not have caused the victim to bleed to death if they weren't haemophiliac, if they didn't have haemophilia. And so the result is that you cannot argue that the condition that the victim had was a new intervening cause, or as a way to break the chain of causation for the defendant's actions. If you were, for example, to hit an individual in the face, but it turns out that that individual has some kind of blood clot in their brain, and the resulting attack to that person's head causes that individual to die as a result, you cannot argue that you are not responsible for that death because you hit that individual not assuming that they were going to die. You take the victim as you find them. So the condition of the victim does not break the chain of causation in that regard. Finally, then, let's talk about this 1975 case of Crown and Bly, or Blue. In this case, the defendant attacked a woman and had stabbed her. The victim was a woman and stabbed her. The attack had caused the victim to suffer a pierced lung. Now, when they went to the hospital, the victim actually refused to have a blood transfusion. Now, this blood transfusion would have saved her life. And the reason why she refused to have this blood transfusion was owing to her religious beliefs. She was a Jehovah's Witness. And for those of you who do not know, Jehovah's Witnesses do not believe in blood transfusions. There are lots of very controversial examples of cases where the parents of Jehovah's Witnesses have tried to refuse hospitals administering blood transfusions to their children, which may save their lives. Ultimately, a lot of controversial debate can be had about the religious liberty of an individual versus the life of either their children or themselves, whether or not a doctor would have to essentially respect the beliefs of this particular individual. Ultimately, the defendant was convicted of manslaughter because the victim ultimately would die, and they've appealed on the basis that he argued the refusal to receive a blood transfusion was not only unreasonable, but it also broke the chain of causation. Okay, because if it hadn't have been for the fact that she had a refused a blood transfusion, it would have saved her life. The blood transfusion would have prevented her from dying, and the defendant would only have been charged with ABH or GBH or some kind of other non-fatal offence because she would have been alive. So the idea of a charge for manslaughter is suggestive on the fact that it was the defendant that directly caused the attack, and the blood transfusion did not represent a new intervening cause, or shall I say, the refusal of the blood transfusion. Ultimately, the court argued that the refusal to have the blood transfusion did not constitute a break in the chain of causation, and so as a result of which the defendant was not entitled to claim the victim's refusal to get a treatment was a novus actus interveniens. Now, I'm not going to lie, this is a very controversial case, and the concept of the thin skull rule in this regard, and the taking the victim as you find them, is essentially applied here to religious beliefs. Whether or not religious beliefs are so fundamental to an individual's characteristics and an individual's life that they represent something like a condition, in the same sense that stabbing someone who had haemophilia represents an application of the thin skull rule. Some people argue that this does represent a new intervening cause, and that religious beliefs should not represent something that doesn't break the chain of causation. Some agree with the Court of Appeal and held on the argument that the defendant should have been charged with manslaughter, and so as a result of which there was no breaking in the chain of causation. This is a controversial case, so debate it in the comments if you wish.